Yeah, colleagues, today, December 5th, 2025, the advisory group of experts has gathered in full force for interview with the candidate for the position of a judge of the Constitutional Court of Ukraine, Mr. Oleksii Klymenko. All six members of the group of experts are present. The secretary, Madam Marina Corner, members Yaroslav Romanyuk, Aleš Zalar, Mr. Vasil Shakun, a member of the advisory group of experts, Madam Anna Sukhotska, and myself, Oksana Vasilchenko, chairperson of the advisory group of experts. At the meeting, also 5 deputy members are present of the advisory group of experts, Mr. Kuzmenko, Mr. Machinchuk, Mr. Zubik, Mr. Barrett, Mr. Griffith. I would like to say that we are working in a shelter. In the event of the air alert, the interview will continue with no interruption. I would like to remind you that there is a recording of the interview and it's broadcasting live on the resources of the advisory group of experts and the website of the Constitutional Court of Ukraine. Also, I would like to draw the attention of the advisory group of experts and the candidate about the constraints of using sensitive data and restricted information during the live broadcast. If it is necessary to discuss such matters or such information, the broadcasting will be restricted. We are ready to start, therefore I give the floor to the Secretary of the Advisory Group of Experts, Madam Marina Corner, for a brief introduction of the candidate and reminding of the rules of the interview. I invite you.
Thank you. Thank you, Madam Chairperson. Dear colleagues, and to everyone who is watching, as Madam Vasilchenko has already said, the group will now conduct an interview with our candidate, Klymenko. I'd like to remind you that the interview is part of the evaluation stage of the candidate to determine whether they meet the criterion of high moral qualities. As before, one interview will take approximately 1 hour, and the time limit for answering questions is up to 3 minutes. Traditionally, we ask all candidates to be concise, to answer the questions clearly, unambiguously, and to the point. At the end of the interview, the candidate may make a short closing statement of up to 5 minutes. I'd also like to note that during the processing of the materials on the candidate Klymenko, the advisory group of experts sent him questions for written explanations, so the candidate has had the opportunity to prepare and to provide answers. So I will briefly introduce the candidate. Mr. Klymenko is currently the deputy head of the 3rd Department for the Organization of Procedural Supervision of Pretrial Investigation and Support of Public Prosecution in Criminal Proceedings on Crimes Committed in Connection with Mass Protest in 2013 and 2014 of the Prosecutor General's Office. From October 2007 to May 2021, he held various positions at the Prosecutor's Office in the Zovnevsky district of Zaporizhzhia and the Prosecutor's Office in that region. He has a security clearance for state secrets, and he has over 18 years of legal experience. Mr. Klymenko, if you would like to add anything to the introduction, you may do so now and take up to 3 minutes to do so.
Thank you. We can move to the interview.
And then.
Шановні колеги, прошу до запитання.
Dear colleagues, you're welcome.
Шановні колеги, добрий день.
Dear colleagues, good afternoon. I have several questions that we expect answers for. This is about predominantly your ownership title to homes in the city of Zaporizhzhia. In particular, you since 2008 till 2013, you owned, and also from the year 2020, you again owned an apartment in the city of Zaporizhia on Centralny Boulevard of city of Zaporizhia. You explained in written rounds of questions that this is an apartment in the a new building, which in 2008 was fully invested by your parents, yet registered in your favor. As you have stated in your response to the second round of questions for an amount not exceeding 150,000 hryvnia. Do you confirm that this particular amount of funds have been invested by your parents into this apartment? Yes, indeed. I remember the exact amount was in the contract. From the contents of the letters, the advisory group referred to the parents in order to clarify the amount of the investment. Why did not you refer to your parents in order to clarify the amount of the investment? Could you please clarify this question? Because I know for sure we referred to you on the occasion to clarify the issues related to the investment into this apartment. And I wanted to ask a question, whether you have asked your parents to clarify the exact amount of their investment into that home. If not, why? I did not, because I remember for sure this exact amount of investment. As for other clarification questions, which were about the origin, as I understand, of the savings, I have explained that I did not inform them of my participation, and the point is that my parents are quite elderly people, and now with the events of the country, say in the city of Zaporizhia, they have a lot of tension in their situation, and actually I would not like to bother them. I don't inform them about any difficulties which would add more tension in their lives. Therefore, this number is known to me and I have notified. Uh, Meanwhile, in the answer to the second round of questions, you explain that your parents uh, have invested, seem to have invested in this apartment in the year 2006, 2007. And while answering the fourth round of questions, this could happen in 2006, 2008. The question is, when did exactly your parents make the investment payments? When I wrote that it was invested in 2006 or 2007, this was the date of signing the contract. I don't remember the exact data because we did not preserve the contract. However, during this period from 2006 or 2008, when exactly the payment was made, this amount was invested for the full payment under this contract. And I don't remember the exact dates of exact payments, and the documents did not preserve. Could you please explain the sources of origin of the funds for investment into this home? I have explained in my replies, I can explain once again, that all these expenses have been the savings of my parents. Having in mind several questions which have been sent to me, I would like to explain that it did not include all of the income of my parents, in addition to those which have been quoted. For example, information from the tax authority, starting from the year 1997, the previous income was not included before 1997. Also, there is no information for the year 2007-2008. Personally, it was not sent to me. This information was not sent to me. I have pointed to the income which was known to me. Of my father, I would not like to discuss publicly. If you are interested, shall we stop the broadcasting? Then I can quote all of the numbers which I notified in writing. It's not so important. Shall we move to the next question? Taking into account your written answers to the questions of the advisory group, 1 square meter of this apartment was 2,500 hryvnia. At the same time, according to the information from open sources, the average cost of apartments in Zaporizhia as of October 2007 was approximately 1,152 US dollars, or the equivalent of nearly 6,000 hryvnia per square meter. As of 2008, the newly built apartments in Zaporizhia city were sold for 5,791 hryvnia per square meter, which was twice as big as the price per square meter that you have quoted. How could you comment such a circumstance? I have explained in my written reply, and I can confirm this, that actually the market value of that apartment was obviously higher than the apartment which is invested at the stage of construction. This is the purpose of investment, in order to buy the flat cheaper compared to the market price. I remember such a moment that this building was not finished. It was unfinished for so many years, and actually by the developer it was bought out. The book value of the entire building under some documents was 887,000 hryvnia. I was surprised that 7 to 8 flats and actually are valued as the total value of the building, of the apartment block. As for mismatch of the value, I would like to say that in that period, probably everybody remembers that in Ukraine, due to availability of lending, there was an increase of the prices of homes. In few months, it has increased. The price of this flat was fixed at the moment of signing the investment contract. It's not fully clear to me what is the point of this question. If my parents found a flat which is cheaper compared to the market price, I believe this is a good transaction. It was beneficial transaction for them. And also I have informed about it, and I reiterate that my parents did not occupy any positions in the government or local self-governance. Therefore, no constraints under anti-corruption law by purchasing assets for lower prices were not eligible to them. I was a student at that time, and I could not foresee that such questions will appear in the future from the group of experts during my interview. The purpose of our questions is to clarify the sources of funds for which the home was purchased. Now we have another question. For what purpose? In the year 2013, you presented this flat to your father as a gift, and in 2020, the father presented it back to you as a gift. You gave the answer that my father has requested to do so. I confirm that actually this apartment was bought by my parents. The actual owners and the people who earned the money for it have been my parents. Yet I did not earn money for the home of my own. Therefore, my father has his own plans for the real estate that he bought, and he requested to transfer this flat in his favor. In the future, having in mind that they are not young people, it was decided to transfer this flat during their lives, not to be concerned about inheritance. This is a far-reaching decision. That's all from my side. I give the floor to my colleague, Mr. Alarzadar.
Thank you. I have just one question related to the last question. When your father asked you to give the flat back to him, did he tell you what he wants to do with it?
Regretfully, I don't remember now what motive did he have.
So long ago, this was in 2020.
Ви маєте на увазі, коли він мені
You mean when he transferred it back to me? Actually, the reason was that later on there is no problem for inheritance.
Concerning your professional activity, as you know, there were court decisions in your claim against the Zaporozhye Regional Prosecution Office for cancel the order that was a violation of the time limit for consideration of 4 petitions in 2018, which resulted in a reduction of your bonus. So can you explain the circumstances of the violation of the deadlines for responding to those petitions?
пояснюю.
I can explain. There were two statements of crime which have been filed by a member of the Oblast Council. His name was Zotov. Yet they have not been registered in line with the Article 214 into the Unified State Registry, and the management decided to provide interim response to them, to such statements, and also to assign the prosecutor office of Energodar to review, to inform on the merit, and then we would provide a response to the claimant as a member of Oblast Council. My objections that the registration should be made with state registry, and by jurisdiction the case should have been transferred at the place of commitment of crime was not taken into consideration. Therefore, I wrote a report of extension of the time frame of review of the statement, and the interim response was provided on 10th or 11th day, which was considered a violation of the time frame of review. However, actually, the final reply was provided on time, and none of these statements was registered as the one reviewed in violation of the deadlines. Also, two other statements have been filed. The situation was that I was on business trip. I was seconded. I have to look into materials. In my claim, in my response to claim, I describe in detail, and within the framework of that, I provided information during the written questions. The situation was that I had my term of the secondment had expired in that division where the statements were reviewed. I developed draft responses on my own. I was not authorized to independently give replies to such statements. Draft replies were prepared on time. Why have not they been signed or not shipped, not sent? I don't remember. Or one should have revised them, and they have been revised and they have been sent, and this shipment was delayed. Probably this was the situation. However, I was not seconded in that to that division any longer. Yet it was decided since I was preparing the draft replies, and before the end of my secondment, they have not been finalized. In that case, I was demotivated of the bonus. And actually, if we read into the formula, in the personal case, there must be the formula. It's not clear for what particular reason was I demotivated of the bonus. I tried to challenge this. I expressed my arguments, yet the court did not review on the merit. They decided this is the authority of the management to provide or deprive of the bonus.
Thank you. You explained in the written rounds of questions and answers that there were no other similar cases in your career. Can you explain what were the motivations for the prosecutor's order to actually reduce your bonus due to untimely consideration of petitions?
Уточніть, який наказ?
Can you please clarify what kind of order of prosecutor you are talking about?
In order to reduce your bonus pay due to untimely consideration of petitions. So what was the motivation that this was done?
Я вже надавав відповідь на це запитання.
I have given I don't know the motivations, why prosecutors, what were their decisions based on. Unfortunately, at that time, the situation at the prosecutor's office in Zaporizhia region was such that the thought that contradicted to the opinion of the supervisor was not accepted. And why they decided to deprive me of the bonus, I don't know. I gave this answer in my explanations, and I confirm right now that my opinion is such that there was a very unobjective attitude towards me from the supervisor when I appealed to the with appeal. I don't know for sure the reasons. I don't know any of the person who prepared these documents and who signed this paper. This person didn't discuss his motives with me.
I'm passing the floor back to my colleague Vasil Shekun.
У нас виникли деякі
We have some questions related to the declarations of your property. For example, in the electronic declaration for 2020, you did not declare the receipt of an apartment as a gift in sections 11, income including gifts, and 14, expenses and transactions of the declaring entity as a gift transaction that resulted in the acquisition of the right. Why? Can you explain?
Незазначення цих
I have explained already that in these chapters I made a mistake that I didn't declare, but as soon as this legal act happened, I showed it in a separate declaration on the change of the property status. And at the moment, there is a norm, if I'm not mistaken, in the Act, Article 46 in the law of crime of corruption prevention, that non-declaration in a separate chapter, if it was in another chapter, this is not a violation. It's not the violation of declaration. So this is stated that it's not the act of violation. Okay. You did not disclose the value of the apartment in your electronic declarations for 2015, 2019, although you were a party of the relevant gift agreement dated 19th of December 2013, where in paragraph 3, its expert evaluation is reflected as 333,435. Can you explain? I have already explained the gift agreement was concluded in 2013. I did not order this expert evaluation. It was done in the automatic regime, and I think the notary entered the statements in the database, and the report was published at the end. At that moment, this was the 2013, they started declaring entering this data into the declarations. First one in 2015, it was entered into the base in 2016. I didn't have this agreement. I just forgot that it was being assessed. So I did not include the cost of it. Okay, understand. Next question. According to your declaration for 2024, on the 20th of June 2023, you acquired 133 pieces of securities, but did not indicate their nominal value in the declaration and did not provide information on the location of the issuer. Can you explain why? Because these securities, they have no nominal value. They are linked to the market rate of gold. I have nothing to indicate. Speaking about the issuer, unfortunately, they were acquired through mobile app, and there was the name of PDR Trust, if I understand correctly. However, I did not find the place of location of this legal entity in the open sources. In the mobile app, information on the issuer is limited only with the name, with the title. So I didn't have this information in order to indicate it. I don't know any of the addresses of the legal entity which is indicated in the mobile app. The securities, you still have them? You still own them? Yes. Do you declare them? There will be declaration for 2025. I will declare them. The last in the last security declaration there was information on securities. Next one. As you stated in your answer to the first round of questions, your ex-wife and stepdaughter lived with you in the rented apartment in Kiev from 2021 to 2022. Why did you not indicate that they had the right to live in this apartment in the section 3 real estate objects in your electronic declaration for 2021? I have been asked this question a couple of times, and I explained as much as I could. There is a little contradiction here in the formation of declaration, which we had to fill. The state envisages declaration of objects of property. All objects that were in the property of mine, they were portrayed completely. At the same time, the rent agreement was on my name. And ex-wife and stepdaughter started living only after we registered our marriage. This was the 1st of December. By the end of the year, on the 31st, they returned to Zaporizhia for the New Year holidays. And therefore, I do not have the duty to declare the object, the same object twice. In the explanations, it's indicated that there is a right to use, and I did not find a right to use. What right in the explanations? What right does the wife have? So I did not have the duty to declare it. In 2022, after full-scale invasion, they left Ukraine abroad, and they lived in this apartment until the 24th of February. So it's less than 6 months in order to indicate them as persons who lived in the apartment. It's clear. During 8 years, since 2013 till 2021, your ex-wife was engaged in entrepreneurial activity. The place of her registration was a real estate object located at the following address: Zaporizhia region, Vasiliev district, village of Shevchenko. At the same time, in your electronic declarations for this period of time, you did not provide information about your ex-wife's use of the real estate property under which she was registered as a sole proprietor. Can you explain why?
Можу.
Yes, I can. First of all, until 2021, I shouldn't have registered anything about her property. As I have explained, from her words, she, at the moment when we got married, she did not have the right for this property because practically she belonged. It belonged to her grandma who died many years ago. But after the sale of this property, she by the registration, she was registered at this address, but she didn't have any rights for this property at all. That's why I didn't indicate, and none of the information was indicated about this object of property. I don't even know where it is exactly. Okay. That's all. I'm giving the floor to my colleague, Mr. Zalar.
I have another question, which relates to the legal entities of your close relatives, which were shareholders. Your close relatives are the beneficial owners of two legal entities. Elektrovenzavod Limited Liability Company, and these are father and brother, and Zaporizhia Energozavod Limited Liability Company, and here owner's mother and another brother. So the first of the companies carried out export and import operations with counterparties from Russia until 2022. The other maintains such ties until 2020. What do you think how an outside observer perceives such ties with the aggressor country after 2014?
Враховуючи
Taking into account that this relates to my family members, can you please stop the broadcasting so I could easily answer the questions? Yes, please. continue with the broadcasting.
Ask now while we're off broadcast. And it has to do with going back.
Just a second. Just a second, Ms. O'Connor, just a second. Let us stop.
So now the broadcasting is renewed. Do you have any more questions to the candidate? Unless there are questions, Mr. Klymenko, you can make your final statements up to 5 minutes. Dear advisory group, I would like to thank you for what you are doing. And in spite of the results of the competition, personally for me, I believe it's a great breakthrough in having the process of appointment of judges of the Constitutional Court. I hope you will recommend for the appointment the best candidates. Also, on my own behalf, I would like to add that Ukrainian people deserve that they have the best government, including the judicial branch. Thank you for attention. Thank you very much for your answers, Oleksii, dear colleagues, dear public. Saying this, the interview with the candidate for position of the Judge of Constitutional Court of Ukraine, Mr. Oleksii Klymenko, is considered closed.